it's always, the concentration span gets divided. And when you have a technical topic like service tax and controversies, it's always going to be a bit difficult to take some of those positions. I'll try my level best to stand up to your expectations. The topic which is allotted to me, I was just reflecting on it, controversies in service tax. And I was just thinking that where does this word controversies come from and why is it required? I think the fact that there is a controversy comes from the situation that a single sentence can be interpreted by different people in different fashions. And I think that is where I have a very beautiful story to narrate. Can we have the slides? Can we load the presentation? The story is about a small garden, a beautiful one, having lots of flowers. The gardener was necessarily concerned that children who will come there and play will pick up and pluck flowers and destroy the entire garden. So he put up a small notice board in the garden which said, please do not pluck flowers. Fine. So this is a rule. Please do not pluck flowers. Yes. So he put up a notice board of this nature. Please do not pluck flowers. This is a rule. Went on well. The garden was well maintained, had lots of flowers and small plants with a beautiful colors and range of flowers. One fine day, people who could interpret law or people who could administer law, both of them went in the garden. They read this rule. Please do not pluck flowers. But their children were very insistent and they wanted those flowers. So how do you interpret this rule? They did a very simple thing. They said the rule says you cannot pluck flowers. It doesn't say you can't pluck a plant. So what they did was, they took out the entire plant and necessarily the flowers along with it. So it's the way you interpret it. When you are told that you do not pluck flowers directly, whether you can pluck those flowers indirectly. This is one of the issues which we will touch upon, and that's one of the major controversies which is going around right now for the past period, the first controversy which we have created. But before we go into that, let me spend some 5-10 minutes on some base principles of service tax. I'm sure more or less all of us have been educated on this over a period of time. But yes, I think that it makes sense to keep on revisiting those base principles again and again. We all know service tax is a tax on services rendered by one person to another. But then this sentence itself makes me pause. What is meant by a service? Unluckily, as of today, there's no definition given to the word service under the service tax law. And this is the biggest challenge. Does the receipt of money, which is not goods, necessarily mean service? The service tax department assumes to be so, and therefore you have left, right and center various notices coming up on various people saying that you have rendered some service. Again, the department is not happy by saying it's a service because they have to specify a particular category under which they'll tax you. So they'll try to use a weird category like business support service or business auxiliary service and try to fit you somewhere or the other and say that please pay me a tax. That's the general tendency, and this is how the entire interpretation and the litigation starts. Of course, I would also not venture into defining the term service because if I try to do that, maybe I may not succeed in that. Very frankly, I don't know an answer to that question. And also, what would happen is, I would spend most of the times doing that rather than taking you through the various controversies. But I just want to highlight a couple of illustrations. Let us say a person receives a non-compete fee. Is it a service? And friends, I think from this I want to widen up your thought processes to say that just because something is not goods and therefore VAT is not payable does not mean that it automatically becomes a service. There can be transactions which are neither in the nature of goods nor in the nature of services. We are still to have the advent of GST. Of course, in GST, we'll have a definition of service, which would be worded in a fashion which says any commercial transaction which is not goods is services. But till the time we do that, and for doing that, you'll need a lot of constitutional amendments and a lot of consensus amongst the center and the state. Till the time we achieve that, we cannot really boil down to a conclusion that anything which is not goods is services. Just keep that at the back of the mind. In one of the case studies, we'll revisit this factor, whether in the specific transaction there is an element of service or not. We all know the tax is levied under the constitutional powers, and service tax is levied under entry 97 of the union list, which is a tax on items not specified elsewhere. And from this comes a very beautiful principle laid down by the Supreme Court in BSNL's case, which again we will go into and revisit in each of the case studies as we move forward, which is that there is a mutual exclusivity of service tax vis-a-vis other taxes. A very simple and an illustrated case which is always quoted is, if a transaction is legally liable for VAT, then service tax is not payable because VAT and service tax are mutually exclusive. Friends, yes, this is more or less a settled proposition, but again, I would like to propose something further than that. The mutual exclusivity does not relate only to VAT vis-a-vis service tax. It would relate to many other types of state-level taxes levied on services. A classic case, according to me, is entertainment duty. When you are a broadcaster or you are a cable operator, you are providing an entertainment and the states levy a tax on entertainment, provision of entertainment, an entertainment duty. One has to then question that if the activity of providing entertainment is already covered under the state list under a particular entry, can it again be covered under broadcasting services or cable operator services, and can there again be a service tax on the same transaction? There are, I understand, lots of matters pending before the Supreme Court on this point, and at some juncture the Supreme Court will have to decide on this principle of mutual exclusivity, not only vis-a-vis VAT and service tax, but vis-a-vis other state indirect taxes and service tax. For the controversies which we are going to talk about today, when we go to the real estate sector, we'll understand that there's a tax called a stamp duty. So the same principles we will have to revisit and see whether once there is a stamp duty levied by the state, whether there is something left in entry 97 for the central government to tax. And if there's nothing left in entry 97, whether service tax on the so-called under construction flats, which has been imposed from July 2010, can survive. Of course, we'll have a detailed analysis of that in a subsequent slide. Having said that, yes, it's a tax on services rendered, and it's a tax which applies on selective basis. That is the next aspect which will come out. Only the list of services which are mentioned in the statute are liable for service tax. There's no residuary category taxing all services. And this is where I think the pick and choose approach of taxation starts creating major complications in service tax. I'll give you a simple example. We all understand advocates are also into the service tax now. Earlier we used to say that only chartered accountants are covered, advocates are not covered for similar services rendered by both of them. Yes, to counter that argument, we have legal consultancy services brought into the service tax net since 2009. But the definition is very interestingly worded. It says legal consultancy services rendered by a business entity to another business entity. Now this is where your do not pluck flowers, the principle of interpretation will start coming in. What do you mean by a business entity? They have said business entity means someone who is not an individual. Fine. But when you say business entity, you necessarily presume that the entity is into business. And when I was doing my CA, at that time we had intermediate, the first thing which I learned when I did income from business or profession, I understood that there are fundamental distinctions between the phrase business and profession. So a question which will come up is, does a legal consultancy firm, can you call it as a business entity or will you call it as a professional entity? Again, that's a rule of interpretation. According to me, a legal consultancy firm can be called a professional entity and not a business entity. Moment you take that stand, the entire entry to tax advocates and legal firms falls down, because the definition starts by saying legal consultancy services provided by a business entity. And that by itself therefore becomes a non-starter. So that is where you find at many places there's a lack of application of mind while defining the selective services which are sought to be taxed. Of course, the other points are also simplistic enough. We are saying it's a tax on the gross amount charged, the entire bill value, and it's not a tax on profits. Many times we get questions from clients asking us that, look, I am procuring a service for 100, I am charging